Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, on the heels of Wayne LaPierre's rather sudden resignation as president of the NRA, it had many people speculating what was really going on. And I know many of you have had no problem whatsoever throwing gas on the fire, and I recognize where you're coming from, and candidly, I've done a little bit of that myself. However, I've had an opportunity to read a stipulation and settlement order out of the state of New York that Letitia James, the Attorney General, came to with one of the NRA's higher ranking employees. And I think I have a very good reason why Mr. LaPierre may have had to step down, and that's because he really has got himself in a hard place. Don't believe me? I'll explain what's stipulated in this agreement and you'll understand the vice that Wayne finds himself in. Okay, so the lawsuit we're talking about is the people of the state of New York versus the National Rifle Association et al. That et al. Includes many other individuals, including an individual named Joshua Powell. Joshua Powell was in charge of the charitable wing of the National Rifle Association. He was one of the named defendants in this suit. He has reached a settlement with the state of New York where, one, he admits to his wrongdoing, number two, agrees to pay $100,000 in restitution, and three, he agrees to testify against the NRA in the upcoming trial. Now, I'm just going to read portions of this stipulated agreement, but I want to really pay attention to the stipulated legal conclusions, which means that Powell's legal team and the state of New York Attorney General have agreed that these are the operable facts as it relates to this case. One, Powell, in his capacity as an officer, director, and senior employee of the NRA, owed the NRA fiduciary duties of care, loyalty, and obedience. In addition, as a trustee pursuant to EPTL Section 8-1.4, because he administered property for charitable purposes in the state of New York, Powell had a duty to administer the charitable assets entrusted to his care properly, which is not unique to the state of New York. It is an implied duty when we are actually managing funds or assets which are held in trust. Our duty is we have a fiduciary duty to the trustees to manage the assets whichever benefits them the most. It's not unique for states to have laws like that. But then the stipulated findings also include two, Powell admits that he breached his fiduciary duties of care, loyalty, and obedience by, inter alia, using the NRA's charitable assets for his own benefit and the benefit of his family members. In other words, that would be called embezzlement in many states. The findings also state, three, Powell further admits that he failed to administer the charitable assets entrusted to his care properly. Four, Powell further admits that the conduct referred to in paragraph 2 and 3 of this section violated sections 715 and 717 of the NPCL and sections 8-1.4 of the EPTL, and that as a result of such violations, he must pay restitution in the amount of $100,000 to remediate the harm to the NRA. Wow. Those are pretty salacious allegations. Of course, Powell has signed off on those. Now, there is some stipulated relief that comes from this. That is, certain things that Powell must do. One of them includes this. 7, Powell agrees that he will accept service of subpoena for appearance at the trial. Trial includes any and all stages of the trial proceeding in this action, including the jury and bench trial stages, pretrial or post-trial proceedings, or retrials of this action, and will appear at the trial for as many days as are deemed necessary by the Attorney General and will provide truthful testimony. That's not all. There's more. Powell further agrees that A, he shall be responsible for all fees and expenses in connection with his testimony at trial. B, the subpoena referred to in this paragraph may be served by electronic means without tendering witness fees by email upon his personal email that has been used in this action. And C, that such service shall be sufficient under CPLR 2303. Which not only has he agreed to testify, he basically has already accepted service. So he is showing up and he is going to testify. And who do you think Mr. Powell is going to be pointing the finger at as to some other individual who may have been dipping into the cookie jar? Now, Mr. Powell will be subject to cross-examination, and he certainly did get a benefit from agreeing to this testimony, because the stipulated order also says, dismissal of lawsuit with prejudice. In consideration of the covenants undertaken herein, plaintiff agrees that the claims against Powell in this action shall be discontinued with prejudice on the effective date, the date when this stipulation is so ordered by the court. Essentially, he is walking away from the lawsuit. Granted, he is paying $100,000 in restitution, which is a huge chunk of change, but all of this is contingent upon one thing and one thing only, which means he has to testify in court against the rest of the NRA. That, my friends, is the vice that Wayne finds himself in. Okay, the case once again is the people of the state of New York versus the National Rifle Association of America et al. We will go ahead and link up the settlement order down below so you can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is also down there in the description box. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.